Good evening, everyone. Good evening. Welcome to the second class of the week, and hope we are fully prepared for another master class. Please, party chairman, please rally around your members. It's time for class. And we have the next 5 minutes to call on the members of your party to join the class in time. See you in another 5 minutes. Thank you. Party chairman, I think we can do better. Members of the party, we shouldn't be less than 100 at least for a start. And what we have here is just 69. Yeah, 70 now. And the next 1 minute, we delve into today's business. Oh yeah, good evening once again, ladies and gentlemen. Welcome to the Electoral College School of Literacy and Governance. And it's our 17th cohort and second class this weekend. Our topic for today is constitutional development in Nigeria. And our facilitator for today is Mr. Levino Sobiang. Kindly follow me while I read out and introduce him through his portfolio. Mr. Ibiang Levinos is currently a public health and biosafety expert and a professional in politics with over 19 years working in the social sector to strengthen institutional reforms that can lead to social change. He had led several student youth movements and have been involved in human rights advocacy. He was a former FCT interim chairman of Alliance for New Nigerian Party, ANN, and it was under his leadership that the party built the structures at the local government and ward levels before his ascension to the office of the national vice chairman of the party for the South-South zone after the national convention in 2018. In this capacity, he served in several committees, prominent amongst which is the Security Committee, which he chaired, the Partnership Committee with other parties for the general elections in 2019. He was also a member of the National Campaign Council of the party and served as the South-South Zonal Director and Chairman of the National Campaign. Mr. Ibiang is a graduate of the University of Calabar and holds several certifications in his chosen field. He holds, in addition, a master's in business administration from Ahmadu Bello University. He is currently a PhD candidate in international public health. Ladies and gentlemen, please join me in welcoming Mr. Levinos Ibiang, our facilitator for today's class. Thank you. You're welcome, sir.
Thank you very much, Samsudin, for that intro. Please confirm you can all hear me very well.
And yes, can hear you, sir. You're welcome.
Okay. All right. Once again, good evening. Let me take this moment to appreciate the leadership of the Electoral College under the erudite leadership of the Executive Director, Kunle Lawal, and his team. The deputies, Lisa Wumi, and other staff and management of the Electoral College, and to also welcome the participants of this particular cohort. It is indeed a pleasure to be with all of us once again to talk to us about constitutional development in Nigeria. And this is very important because of it's important for us to understand how we evolved to where we are today. And that's why we want to briefly look at constitutional developments in Nigeria. But before, this is going to be the outline for my presentation. I'm going to do some introduction and then we'll look at the pre-independence constitutions. We'll also look at post-independent constitutions. We'll look at the military rule and constitutional development. What role has the military played? Because within the Nigerian political space, as key actors, we have the military as well within that circle. And then we'll look at the return to democracy, our democratic march from 1999 to date. And we'll look at also some constitutional amendments and reforms or attempts to reform our constitution, and then we'll conclude with some questions. Before I delve into the subject matter today, I just want to give us a little bit of history, just so that we can appreciate where we're coming from. Nigeria as a political entity. It's essentially a colonial creation. And this is something that all of us already know, because we hear people talk about, oh, Nigerians did not come together to form Nigeria. So it was the colonial masters that fused us together in 1914, what we call the amalgamation of the southern and northern protectorates of Nigeria. And we'll see all of that. So it was the British colonial agents that made Nigeria to be one. And prior to the British imperialist adventure, it's important to understand that there existed some sort of independent empires and kingdoms, and even chiefdoms, clans in Nigeria. And you will agree with me that in most communities, we still have, these clans. And these chiefdoms and clans are so well decentralized in a republican nature and within our society, and have some level of interactions between them. For instance, in the north, you have what we call the Hausa Fulani people of the north, who lived under a highly centralized political system called the emirate. So you have the emirate structure, with the emir being more or less an absolute ruler. And in the west, where you have the Yorubas, there were various kingdoms headed by Obas, who were constitutional monarchs, as it were, and ruled through a variety of council of elders, and in fact have what you call secret societies. Okay. And in the east, where you have the Igbos and the other culture nationalities. There were also organized and highly decentralized republican structures within the eastern part of Nigeria. Now, it's important for us to have this background so that we can appreciate the evolution of constitutionalism in Nigeria. Now, the British influence began with the appointment of one man called John Beecroft, who was placed as a consul over the Bight of Biafra and Benin somewhere in 1849. And initially, he resided in a place called Fernando Po, in Equatorial Guinea. But later on, relocated his headquarters to Calabar. So the activities of these consular agents actually resulted in the signing of a series of treaties back then with the people of the coastal territories, because the coast was the access into the midlands of Nigeria. And then these treaties, of course, resulted in the bombardment of Lagos in somewhere 1851, and its annexation as a British colony in 1861. So after some time, Lagos was placed under the administration of a governor in Sierra Leone, and later under Lagos became a colony, So there were different authorities, which of course were in Nigeria to enable the British effectively occupy Nigeria. One of these authorities is what we call the Royal Niger Company, the colony and protectorate of Lagos, under the colonial office in London. And then we have this area called the Oye River Protectorate. We'll go into that. I'm just trying to give us some background so that when we begin to look at the evolution of the constitutions, we will understand why we had all of this happening. So the Oye River Protectorate, which was later renamed as the Niger Coast Protectorate under the jurisdiction of the Foreign Office in London. And then in 1900, we had the Royal Charter, which empowered the Royal Niger Company to administer some parts of Nigeria, was now abrogated. And the British government assumed direct administration over the entire area. So it wasn't the Royal Niger Company anymore, which was like a third party. So the British government assumed full control. Now, what follows next was actually very interesting. And then we started having this series of events that later took place, which is what I'm going to be speaking to us about. Now, having given us that bit of background, what then is a constitution? Because we are going to look at constitutional development. Constitution has been variously defined. And if you look at what we have here, we have scholars who had attempted to define constitution. And here we have that it's a fundamental legal document that outlines the basic principles and laws governing a country. And we had all the definitions by different scholars already on, and Professor Ben Wabo is a constitutional lawyer, also defined the constitution as an act of the people if it is made by them, either directly in a referendum or through a convention or constituent assembly popularly elected. So you see, if you look at this definition critically, you will understand a lot of the criticisms that we've had about the current constitution that we had, because it was not really a product of people coming together to actually give themselves a constitution as it is supposed to be, and just like Professor Bernard has indicated. But be that as it may, we have a constitution. So our constitution, of course, is the ground norm, and it is the supreme law in our country. And as a supreme law, it has set forth the framework of government. And when we talk about the framework of government, we are looking in terms of structure, where it defines the arms of government, organization of the arms of government, the branches of government, the powers, and the responsibilities. And then in terms of functionality, it has also defined lawmaking process, who makes the law. It has defined implementation, who implements the law and enforces them. And then in interpretation, it has also defined who interprets the law. It is common knowledge to everyone that lawmaking is the business of the legislature. Law implementation or enforcement is the business of the executive branch of government, whereas interpretation of the law is the business of the judiciary in Nigeria. Secondly, the ground norm has also established what we call the prescriptions of the principles of governance, which of course include the rule of law and of course separation of powers. So between the different branches of government, there are checks and balances in between, so that we don't have the tyranny of the few. Because if you look at the percentage of people who occupy the executive branch, the legislative, and the judiciary, it's just a small fraction of the entire, a small percentage rather, of the entire population of Nigeria. So these principles of governance worked to ensure that there are checks and balances between the different arms of government or branches of government. And the rule of law ensures that both the people in government and the governed are under the law. So none is above the law. So whether you are elected into office or appointed into office, you are not above the law, you are under the law. So that makes everyone equal before the law. That's why you talk about equality before the law. And it is only then you can talk about the rule of law. The same constitution has set forth the rights and freedom. So you have fundamental rights, which deals with the protection of individual liberties, rights such as freedom of speech, freedom of assembly, freedom of religion, freedom of association, and all the rights of the citizens. And then it also establishes equality, which guarantees equal treatment. Of course, I mentioned that earlier. And then the same constitution established a process for its amendment. Every constitution must have a process for its amendment. So the Nigerian constitution that we have today had also established that. And it has also set forth or defined supremacy. So it defines the constitution as the highest legal authority. And if you look at the constitution, it clearly states that this constitution shall be supreme. Okay, and it has binding force upon everyone in this constitution, in this country. And it also clearly established that any other law that is inconsistent with the Constitution of the Federal Republic of Nigeria shall, to the extent of that inconsistency, be null and void. That again establishes the supremacy of the Nigerian Constitution. So no other law can be bigger than the Constitution. No other law can equate itself with the Constitution. Every law has to subject itself to the Constitution. And if it is inconsistent, then it is null and void. Now, again, let's look at some historical context to constitutional development in Nigeria, and specifically looking at the pre-independence Nigeria. The pre-independence Nigeria actually featured 5 constitutions that were adopted at different periods for historical evolution. And we'll be looking at all of them. First of all, take note of these important timelines or milestones as the case may be. In 1886, there was a charter that granted the Royal Niger Company to administer the protected territories in northern Nigeria. Remember when I was giving that background, I did say that the British colonial imperialists ruled through a proxy, and that proxy was the Royal Niger Company. And it did this by a charter that was granted the Royal Niger Company to rule over or administer the protected territories in northern Nigeria. That charter was later, revoked or abrogated, and the British government assumed direct administration of these territories. So in 1899, the Protectorate of Northern Nigeria was established following a revised charter. Okay, and then the Oyo River Protectorate was established in 1893. I mentioned that when I was giving that background, and later changed to Niger Coast Protectorate. This I also had alluded to. And then in 1900, the Southern Protectorate was proclaimed. It was proclaimed. And in 1906, there was the first attempt to build a nation when the colony of Lagos and the Protectorate of Southern Nigeria were fused into what we call the Protectorate of Southern Nigeria. Don't forget, there was the Oyo River Protectorate, which was separate. It was still in the south. Then you had the colony. Lagos was a colony. Remember I said there was a governor that was placed over Lagos, who was based in Sierra Leone, but that was later, disbanded, and Lagos became a colony of its own, okay? And the headquarters was no longer in Sierra Leone, but in Calabar. Now, the colony of Lagos and the Oyo River Protectorate, which was later called Niger Coast Protectorate, were now fused together to form what we call the Protectorate of Southern Nigeria. So in the north, you have the Protectorate of Northern Nigeria, and then we have the Protectorate of Southern Nigeria. So in 1912, Sir Frederick Lugard returned as the governor of Nigeria, the governor of both the Northern Protectorate and then the Protectorate of Southern Nigeria. And then this, of course, set the pace for what will then happen in 1914, which was the amalgamation of Nigeria as a colony of the British Empire. Wherever you see BE here is British Empire, and as a protectorate of Nigeria by Sir Lord Lugard. So we now had one protectorate, which was Protectorate of Nigeria. So some major developments. So if you look at it, with the Southern and Northern Protectorate amalgamated in 1914, it was directly administered by Sir Frederick Lugard in 1914 by whatever laws he has made. And those laws, of course, by which Sir Frederick Lugard administered Nigeria were regarded as, the Lugard Constitution at the time. And what was the central element of the Lugard Constitution? One, it provided opportunity for the expression of public opinion through a non-legislative Nigerian council, which was, of course, an advisory council. Okay, so it was just established to give voice to people. So only matters of interest during the previous year explained, matters of interest during the last year and explained any questions of policy and legislation, especially as it concerns the governance of the non-protectorate of Nigeria were discussed under the Lugard Constitution. And the Nigerian Council at the time was basically just 36 members, including 6 Nigerians nominated to represent the coastal districts. The coastal regions were very important because they were the access into the midlands of, in the hinterlands of Nigeria, and then the interior of the country. And then we had that these 6 Nigerians consisted of 2 emirs from the north, the Alafin of Oyo, and 1 member each from Lagos, Calabar, and Benin, Warri area. And then Lugard's term in office ended, and we had Sir Hawk Clifford, who assumed office as the Governor General of Nigeria. Now, if you look historically, most times you will never hear about the Lugard Constitution because it wasn't, many scholars do not see the Lugard Constitution as some sort of constitution that can be cited or relied upon. What you mostly see is the Clifford's Constitution and then all the other constitutions that will follow as we continue in the series. So the Clifford Constitution came into force in 1922, and what were the central elements in that constitution? One, it established the first formal constitution. So you see what I'm talking about, why many scholars do not really see the Lugard's constitution as, as an authority to be referenced. So the Clifford Constitution established the formal constitution in Nigeria. It created a legislative council with limited representation, okay? And only educated elites could actually vote under that constitution. It aimed to address colonial governance, but lacked broad political participation. Of course, that was expected, okay? And the new council legislated for the whole of the southern Nigeria, but the council could debate the estimates of the whole country. This was what some of the scholars who had researched into that constitution were able to observe as key features of that constitution. And then it provided for a total membership of 45. So you see that the number increased from 36 to 45. That means we had more people. And it consisted of 26 official members and 15 nominated members. So according to Yoleye, for the first time in Nigeria, Lagos and Calabar were granted the right to vote in an election to the Legislative Council. Now, if you recall when we were doing the history of political parties and structure, I did mention at some point that there was a time that franchise was limited to Lagos and Calabar. Franchise here refers to the right to vote. Okay, it was only limited to Lagos and Calabar. So this was largely because of the Clifford Constitution, which provided for franchise in Lagos and Calabar. So 3 seats were allotted to Lagos and 1 seat was allotted to Calabar. So apart from Lagos, it shows the status of Calabar as an intellectual center at the time. And it should also be noted that Calabar was the capital of the Oil River Protectorate, created by the British in 1891, which was later renamed in 1893 as the Niger Coast Protectorate. All of this I've talked about when I was giving the background. So those were the key elements of the Clifford's Constitution. And after Clifford's reign, we had Sir Otto Richard, who became the governor of Nigeria. And his constitution was popularly referred to as the Richardson Constitution. So, and these were the main elements of the Constitution. First, it established for the first time the Executive and Legislative Council and expanded representation in governance. So we are now started seeing some semblance of, you know, the kind of systems that we have today. So we have the executive and then we had the legislature. Recognizing Nigerians' diversity, okay, identifying that there are different ethnic groups. So it created 3 regions, the North, the South, and the East. So it was Richardson Constitution that created the North, the South, and the East regions, just to expand the space and allow for some sort of representation in the Legislative Council. However, it's also important to note that in creating these 3 regions, okay, there were regional council, which were largely an appendage of the Central Legislative or National Legislative Council sitting in Lagos at the time. So yes, there were legislative council for the different regions, but they were more like an appendage of the National Legislative Council. So the regional councils were not granted full legislative status or powers. And this, of course, set the stage for increased political engagement and regional autonomy. So having created the regions, there were now agitations to have decentralization of powers, what we call devolution of power. So all of those terminologies that we hear today, they were not just from today. They've been there a long time and for a purpose. So it's also wanted to note that this constitution was widely criticized for lack of consultation. And I put that in bold so that we understand why the Richardson Constitution or what the Richardson Constitution also suffered in terms of criticism by the elites at the time. So those were the key elements of the Richardson Constitution. And then we had the Maferson Constitution of 1951. Sir John Maferson became governor. And what did he do when he came on board? He also established the Maferson Constitution with the following elements. 1, the Nigeria Constitution, or what we call Order in Council number 1172 of 1951, established a central legislature made up of a single chamber called the House of Representatives. So we started from having just a single legislature, which was called the House of Representatives. And then we had the regional houses, of course. We had the regional houses represented by 136 members, members. There was also an executive council consisting of the chief commissioner of each of the 3 regions, and then the attorney general financial secretary, director medical services, director education, and others nominated by the governor. The constitution also approved bicameral legislature for the western region of Nigeria and the northern region as well, through an order in council. So let me also mention that you've heard me talk about order in council. So recall that the British operates a monarchical system, and the monarchy at the time, instead of what you call decrees or proclamations, you have what you call the order in council. The order in council is the instrument by which the British government will establish either a constitution or constitutional development process, or a government or appointments and so on and so forth. So that's basically why we have the orders in council. So for the first time, Nigerians were made ministers, but without ministries, what we call minister without portfolio, which was seen by many as a setback to our manifest, destiny. How could you appoint somebody a minister without a portfolio, without a ministry to administer, as the case may be? So, and then it provided for the establishment of more political parties like Action Group and MPC. So again, as we go through this particular lecture, it's important to note that you need to marry this with the historical establishment of political parties and structure, which we talked about earlier. It gives you a firm, grasp of the entire situation. Now, there were shortcomings of the Mafassin Constitution, but don't forget, the Mafassin Constitution established what was more than what the Clifford Constitution had, set forth, and the Richardson Constitution as well. So what were the shortcomings? Unfortunately, this constitution did not last long. Northern delegates in the Central Legislative Council's refusal to support the motion moved by Chief Anthony Anahorom of the Action Group in 1953 for self-government was, a big issue at the time. While the members in the South saw it as an eventful and historic moment, and the Northern members saw it as an attempt by the South to set in motion some sort of, political hegemony. And so there were those palpable fears here and there. And then we had, of course, the Sardauna, as Ahmadu Bello added to the motto, as soon as it was also practicable. So some of these issues also led to the collapse of that particular government, because these agitations were, very sensitive agitations at the time. And so that took us to some of the developments that follow, which led to the Littleton Constitution. So Sir Oliver Littleton became the governor. You can see that Mafassin's tenure was just for 2 years, and it ended. Now, it's important to note that a product of the public resentment that occasioned the Mafassin Constitution led to significant protestations. And this, of course, resulted, the protestations were against the quasi-federal structure that was established at the time. So in order to correct some of these observations that have been made, there were 2 constitutional conferences that took place, first in London and then the second in Lagos, but both under the auspices of the British Secretary of Colonies. And what happened? Nigeria became a federation comprising 5 units made up of the northern, eastern, western regions, the Federal Territory of Lagos, and then the Southern Cameroons. Southern Cameroon used to be part of Nigeria. And when Herbert Macaulay established the NCNC back then, it was largely somewhere in 1922. It was mainly the Conference of Nigerians and Cameroons, the NCNC. So it is important for us to note this. Southern Cameroon used to be part of Nigeria until some sort of, bilateral horse trading took place. And that region eventually was ceded most recently to Cameroon, I think, under the Obasanjo administration. But this was something that started way back. And so we had the establishment of a Federal House of Representatives with 188 members that were mostly to be directly elected by the electorate. And the creation of the Federal Council of Ministers, which is what we call the Federal Executive Council, which members are to be selected from amongst the members of the Federal House of Representatives. And if you look at that structure, it's almost like what you have in Britain, which is a parliamentary system. So you had the Federal House of Representatives, from amongst which the Council of Ministers were also selected. So that is typically what the allocation of legislative powers to the two tiers of government at the federal and regional levels became very clearer through the exclusive, concurrent, and residual legislative list. So you can see that the Littleton Constitution defined the schedules of the constitutions, which were the exclusive, the concurrent, and of course the residual legislation defined under the Littleton Constitution. Now, remember I said there were two conferences that took place, one in London and one in Lagos. So the first constitutional conference, which happened in 1957, held in London. The first constitutional conference which had was between May 23 to June 26 that were discussed, were creation of states like the Midwest states, Cross River states, and Middle Belt states. The other issues were regions. The Eastern region also got a bicameral legislature at the conference, and it was also agreed that the office of the Prime Minister for the 1957 conference, that the office of the Prime Minister was established, and that the Eastern and Western region should become self-governing immediately after the conference, 1959. This was, of course, by choice of the representative of the region. And then in 1958, there was another conference, the second conference, to October 27 in 1958 in London. And the main issues for discussion at this conference were the recommendations of the minority commission, which was set to address the fears of the minority. Don't forget that we've always referred to three major ethnic groups in Nigeria, but that there are, and remember that the minorities were identified in Nigeria, which of course led to why Rich in Constitution created three regions of Nigeria so that we can have more representation of other nationalities within the regions participating in the governance of that region. And a commission was set up, what was called the Minorities Commission, to look into that and make recommendations at the next conference in 1958. So Nigeria also came up. Recall that that was pushed forward to 1959. So it came up. And then the request for independence, which Nigerian delegates had made, the 1957 conference also came up for Nigeria to become, a sovereign state. And then this conference was attended by 106 persons, variously classed. The conference recorded decisions on fundamental human rights, the police, self-government for northern Nigeria, the position of Lagos, the southern, the minorities problem was also discussed, and of course, Nigerian independence. One of the major highlights was when the colonial secretary at the time, Alan Lennox Boyd, to grant Nigeria independence come October 1 in 1960. So it was, a moment for celebration. Nigerian people had yearned for, moved the motion for Nigeria to become self-governing, eventually was to become a reality. Announcement that was made by Alan Lennox Boyd. Now, we have moved from the Maferson Constitution to a Littleton Constitution to Independence Constitution. And although there were two major constitutional conferences that had evolution of constitutions, okay, from Lugard to Clifford to Richardson to Maferson and then to Littleton, and now we have the 1960 Constitution. So some of the trappings of the colonial administration, colonial legal provisions were also contained in the 1960 Constitution. I mean, for me, I think that's quite okay. Now, what were the key elements of this particular 1960 Constitution? The Constitution created 3 regions of the North, East, and West, along with the Federal Territory of Lagos. So today we have the Federal Capital Territory, Abuja, but before now it was Federal Territory of Lagos. And then the Constitution appointed Her Majesty, the Queen of England, as the head of the executive. So she was a titular president and the head of the executive and judiciary, as well as being a member of, parliament. So that's again what the monarchical system, does. The monarchy is both the executive, the judiciary, and the legislature. And then it did something very interesting. Beyond having the Queen as the titular head, it also established 2 chambers of the federal legislature, the Senate and the House of Rep. And then it set forth Nigerians' transition to self-governance and independence from British colonial rule, as promised in the 1958 conference and as a republic. And then it recognized fundamental human rights and freedom. The office of Prime Minister was then created because the Queen was a titular head. So you needed a Prime Minister who is the head of government and runs the day-to-day affairs of the country. So he was appointed by the Governor General, representing Her Majesty the Queen in the Federation. And then we had the Nigerian Police Force, which was also created by the Constitution, and then it shared powers between the federal government and the regional government. These were the key elements of the 1960 Constitution. Now, in 1963, Nigeria became a republic, and we had what we call the Republican Constitution of 1963. And that constitution defined the structures of governance. It established Nigeria as a republic, basically transiting Nigeria from monarchy to self-government. And it had a federal structure. So it established federalism. And as a federal system, the Constitution maintained the federal system of government introduced in 1954 by the Littleton Constitution, where you have the national and, of course, the regional government with clear division of powers between the federal government and the regions. And the regions were divided into four: the northern, western, eastern, and midwestern regions of Nigeria, with their own government, and some level of autonomy was given to them. And then he set forth the system, the presidential system, with the executive branch. The president was the head of state and government with significant executive powers, and was elected by an electoral college, which included representatives from the regions. And then the prime minister, the role of the prime minister was later was abolished, and the president assumed both the executive and ceremonial roles that the queen was performing. And then we had the legislature. Like we said, we had the bicameral legislature, the Senate and House of Rep, and then the judicial system. All of these were clearly established by the 1963 Constitution. So Nigeria had the military rule, and when the coup happened in 1966, we had the military took over the governance of Nigeria, and this, of course, impacted governance significantly because the military ruled by decree and not by constitution. But then there were constitutions that were midwifed by the military, and we will be looking at them. The first is the 1979 Constitution. Don't forget, when the military took over in 1966, they ruled throughout that period, through the Civil War, until when the Civil War ended in the 70s. And then they continued until 1979. And in between, there were several coups. You had the coup against Gowon, which brought late General Murtala Mohammed as the head of state. And then Murtala Mohammed was also assassinated via a coup, and General Olusegun Obasanjo became the head of state of the country. And under General Olusegun Obasanjo, a constituent assembly was constituted to midwife a constitution for Nigeria. So that was what we refer to as the 1979 Constitution. And this particularly set forth the return to civil rule with the establishment of the presidential system, with all the key features and reforms that followed. So what were the key elements of the 1979 Constitution? If you look at it critically, it retained the very same structures that were set forth in the 1963 Republican Constitution. So I'm not going to delve into it. The only thing I want to point out here is that there were creation of states. So we moved from 12 to 19 states, reflecting the need for more regional representation and administrative efficiency. So that was up and coming. And then we had the other branches of government that were when I was dealing with the 1963 Constitution. So what happened? We had the civilian administration as the president, and the chief Dr. Alex Ekweme, who was the vice president of Nigeria at the time. They had their first term, and then were about having their second term when the coup happened again, and General Muhammadu Buhari toppled that government and became the head of state of Nigeria. And he governed from that 1984 to 1985, late 1983 to 1985, when his government was toppled by General Ibrahim Babangida, who was the then chief of army staff at the time. And so General Ibrahim Babangida became the head of state and commander-in-chief of the armed forces from 1985 down till 1993, when he stepped aside. But while he was head of state, he had also made attempt to midwife a constitution. So in 1989, he set up the transition to democracy and other reforms that took place within that period. And that transition to democracy was what led to the 1993 elections, June 12 elections, which were annulled by his government. And of course, until recently, when he launched his book, I'm sure some of you must have watched that program where he actually came out to acknowledge that late Bashiru Nemkeo Abiola won that election. Of course, like many of us will say, this was something very well known to us because we're all active participants. For me, it was the first time I had to go and vote, in 1983. So it was something very interesting, something very significant for those of us with this process. And part of the reforms at the time were the establishment of two political parties, which was had this Bashiru Nemko Abiola, and the National Republican Convention has a large Bashir, but the Babangida administration annulled that election. And as a result of mounting pressure, because he has set forth a transition process to civil rule, and because of his lack of sincerity, there was so much agitation in the system for him to leave the scene, okay? And he eventually bowed to pressure and pulled out of the military and stepped aside from government. But he did something after annulling the election. This set Nigeria into very significant crises, national and political crisis at the time. And so he set up an interim national government, which was completely alien constitutional. There was nothing like interim national government in the constitution of Nigeria. So he just created it and appointed the chief interim national government. Within the cabinet of Chief Shonukon, a ranking military officer in the person of defense. And of course, while serving as a Secretary of Defense, because of all the constitutional crises, there were litigations against institution. General Sani Abacha, via a palace coup, eased Shonukon out of office and took over the reins of government as the head of state of Nigeria in 1993. And he ruled until 1988 when he passed on. He died. And when he died, there were consultations among the ruling elites in Nigeria, and the then chief of defense staff, who was in the person of General Abdulsalam Abubakar, was agreed to be the head of state of Nigeria. That was how Abdulsalami became the head of state of Nigeria. Then essentially in 1999, he was able to midwife a constitution, which is the 1999 constitution that we using today, and handed over to as a civilian who won election under the platform of People's Democratic Party to become the president of Nigeria. So in conclusion, gentlemen and ladies, Nigeria's political history is replete with major constitutional development, as we have seen. And of course, there are ongoing challenges, debates on federalism, of power, source control, all those things are still there. And the issue of ethnic representation, decision-making organogram of Nigeria. The need is still very much on the front burner. And of course, the evolution of Nigeria's constitution reflects our complex history and diverse society. So all of these issues are still very much issues on the front burner that need to be addressed. And that's why people are still yearning for an constitutional development process, which of course Dr. Goodluck Ebele Jonathan attempted to do while he was president by setting up Friends of 2014. Eventually, his government was cut short, so he could implement the provisions or the outcome of that conference. So those were some of the critical issues within our constitutional development. So these are references that have been used in the course of preparing for this lecture. So I'll pause here. If there are questions. So Sam, said over to you. And thank you for listening.
Thank you so much, Mr. Livinus. As always, insightful, highly packed, and enlightening section. Thank you so much, sir. Thank you. You are well appreciated. Thank you for always showing up and showing up intellectually. Thank you so much, sir. Please signify by a raise of hands if you have any question for facilitator. And would appreciate the female gender participation. Please, for every 3 raise of hands, I'm going to prioritize the female twice. Thank you. Thank you. Okay. Akachuku, please unmute your mic. And
okay, good evening.
Good evening. Please kindly speak up.
Okay. Are you hearing me now? Good evening.
I think it's better. Yes.
Okay. Thank you so much, sir, for this section. It's been like a learning process. Like I've been writing on my notes here, and I thank you once again. So, like, I have just a quick clarification, sir. You mentioned that during the constitution time also that we had 2 constitutions then, sir. I want you to recap again. Like I didn't really understand the aspect of having an other constitution, sir. So I don't know, like, if you understand my question.
Could you take that again, please?
Okay. So I was saying, you mentioned that during the Lord Lugard time that he operated by a constitution. Yeah.
Okay.
So I'm now
Go
like
ahead.
yes, you didn't go like in detail to tell us the details of the constitution.
Okay.
Yes, sir.
Okay, so you're referring to Lugard's constitution, right?
Yes, sir. Yes, sir.
Okay. You recall I did mention that many scholars do not actually view the Lugard's constitution as a major constitution of reference, okay? But of course it existed. It existed because it was an instrument by which Lord Lugard administered Nigeria at the time. Remember, Lord Lugard's appointment as governor of Nigeria was based on an order in council by the British government. So there were elements of that order by which Lord Lugard administered Nigeria, even though in most research documents, you may not see Lugard's constitution. What you see mostly is the Clifford's constitution. You talk about Clifford constitution. You talk about Richardson Constitution, you talk about Maferson, you talk about Littleton Constitution. You may hardly see the Lugard Constitution being referred to, but of course it was there. So, and basically, what I have here is pointing out what was like a key elements of that constitution, what existed at the time. And I did say it provided, of course, an opportunity for the expression of public opinion through a legislative council that was purely, non-legislative Nigerian council that was purely advisory in nature. So basically what we had was a council that was appointed. It wasn't a legislative council that was elected, like other constitution attempted to do. Okay, so that was what we had at the time, and that council could raise questions on policy issues and legislation, but then they do not have the authority to legislate on matters of policy as it were at the time. So the Governor General exercises that full authority over policy issues, over legislative issues, and so on. It was purely the business of the British Empire. So those who were nominated in that non-legislative council only existed as an advisory capacity. That's basically what that constitution. And if you look at it, it was really, really limited in scope as compared to the Cliff Constitution that came made for 26-member legislative, that basically shows you that there is an evolution starting from nothing and then building up to what later became or becomes a constitution that we have today. I don't know if that addresses your question. So I was making the case that most scholars may not mention this. Some will just mention Clifford Constitution, 1979, 1989, and then the 1999 Constitution. Those are some of the things that you will likely find in most literatures.
Thank you so much, sir.
Over
Thank
to
you.
you.
Thank you, sir. Where are the
Thank you.
females, please? And Timothy Olutunji, kindly unmute, please.
Yeah, are you with me, please?
Yes, clearly.
Good evening, everybody, and thank you so much, our facilitator. Yeah, my question is around the constitutional amendment. I don't know if I can ask question about it. You have been talking about different constitution that we have been having since 1914. So, but if I may be permitted, I don't know if it's going to be within the scope of the class to talk about the constitutional amendment. But my question is this specifically, what are the role of the citizens in avoiding instances in which the amendments are serving the selfish interest of the political class? It is observed of late that there are some of the elements of this so-called amendment that tilt towards serving particular interest of some public office officer. Take, for instance, towards the tail end of President Buhari's administration, there was a new police act, and just about a year or so towards the administration of President Tinubu, there was another amendment to that act, and many people believe that it was to actually accommodate the arbitrary extension of the current IG's tenure. And if you have been following too, you will recall that of late, there was a move to actually remove the immunity of the vice president, the governor, and the deputy governor. And people were asking, why did you leave out the president? And you started from the vice president to the governor and to the deputy governor. So now the bottom line is, how do we ensure that the amendment will actually bring about better improvement to our constitution instead of serving the interests of the public office holder? Thank you so much.
Thank you for that very intelligent question. Very practical, and I'll just go straight to addressing that. So the key thing is inclusion, participation. And so the amendment of constitution normally is not limited to the National Assembly. Now, there are two things. Your first question is relating to the amendment of the Constitution. The second one is the Police Act. The Police Act is a creation of the National Assembly. That's why I said it's an act. It is not the provision of the Constitution was to pass laws. Those laws is the police. Any act that was passed by it can also be reviewed or amended by it. But for the Constitution in particular, if it has to be amended, it's an intricate process. Intricate in the sense that it begins from the National Assembly, and then it goes through public hearing. During public hearing, that's where the citizens come in, because that's what your question is asking. How can we be part of the process so that we don't have the elites making or amending the Constitution in a way that favors them? So there is a public hearing process where the public is usually invited. So the public engages with the legislature, raises its own contribution to the proposed amendments that need to be made, and those proposals are then collated and they become part of the working document for the amendment of that provision of the Constitution. It doesn't end there. After that has been done, it is then passed on to the 36 States House of Assembly. The 36 States House of Assembly will also do the same thing that the National Assembly had done. So what most people do, even despite participating in the public hearing organized by the National Assembly, they still go back to the state houses of assembly to also participate, because one of the critical things about democracy is that democracy requires eternal vigilance. Eternal vigilance is very important. And the only way to guarantee eternal vigilance is to be involved in the process of lawmaking, whether at the state or at the federal level. And this is the reason why it is so important for people to be involved at different levels. So it goes to the states, and the state houses of assembly does the same thing, and then pass it, and then they send it back to the National Assembly. What the National Assembly now does, it looks at the submission that have come from the different states. So you must have, for instance, maybe 2/3 of the states of the federation voting in favor of a particular provision to be that is to be amended. And after reviewing the amendment that is to be made, before that can become a law. You get the process. So that
Yes,
is an intricate process, and it has to follow. So that's how the citizens come in. But for the act, the Police Act that you talked about, the process of amendment is slightly different. The National Assembly picks up that, and they do that for a lot of acts that were passed by them. They may call for public hearing, but of course, we know how these public hearings are organized. We need to be vigilant. They may set it up maybe 24 hours to when they are going to meet. So this is politics. That's why we talked about eternal vigilance being very central to sustaining democratic governance everywhere, and which is the reason why the Electoral College is organized. I'm happy to hear this coming from you. It means you've been following the entire process. And of course, with respect to the reviews that led to the extension of the tenure of the IG of police, I have followed those processes, and there have been, we know what we know, and we have what we know. Yeah. So Samsudeen, over to you.
Thank you.
Thank you so much, sir. Thank you for really dissecting that. Is Juliet up?
Hello, everybody. Good evening, everybody.
Finally, good evening.
Please, sir, I have a very simple question. Looking at what has happened in Rivers State and also looking at the Constitution as a guide or a laid down rule for a country or a nation, please, at what point, or sorry, how do we begin to hold the elites or the leaders accountable to constitutional issue when there is an obvious abuse, laying credence to what happened recently that is non-constitutional, the suspension of an elected governor and the replacement of an elected governor with a sole administrator. So how can citizens who are also critical stakeholders in the governance of a nation begin to hold their leaders accountable when there is an obvious abuse on the Constitution? Thank you.
You said it's a simple question, but it's a difficult question. Okay. And thank you so much for that very, very intelligent question. Very practical, because this is something that is right before us currently. My dear sister, I must tell you that, recall I said eternal vigilance is critical to the sustenance of democracy. And who ensures eternal vigilance? The citizens. What? Because one of the most important office in the land is the office of the citizen of the Federal Republic of Nigeria. But look at it. You are here telling me that what happened in Rivers State is an infraction on the Constitution of Nigeria. So, having known that it is an infraction, let me throw it back to you. What have we done as a people? Look at it. Everybody is going about his business, isn't it? Everybody is going about his business. No one had done anything, no protest anywhere, despite the fact that the condition precedent for declaring a state of emergency were non-existent in Rivers State. They were non-existent. Don't take my word for it. The Nigerian Bar Association issued a statement to that effect, that those conditions were not there. But yet, the president went ahead to declare a state of emergency and suspend the government and the legislature, even though the Constitution of the Federal Republic of Nigeria clearly stated that no part of the Federation of Nigeria shall be governed by any means as set forth by the Constitution of Nigeria, which is through election. And then you appoint a sole administrator who is completely alien to the Constitution. Let me quote in the words of a popular lawyer and an actor whom we all know, Kenneth Okonkwo. He said, the president did not declare a state of emergency because the condition for declaring a state of emergency do not exist. That what the president did was martial law. It was a martial law. So he gave another perspective to the whole issue. It was a martial law that was declared in Rivers State, and the military moved in and took over the reins of government. So, bottom line, how can that be checkmated? Every Nigerian went to sleep. We all went to sleep. That is why that illegality is still standing. If the people had stood up against it, perhaps it would have been reversed. But Nigeria is what it is today. Everybody is going about his normal business, and everybody is fine. You know, last, like they often say, last, we'll all be fine. And we are fine, really. So this is the problem. Citizens must rise up to the occasion. We must rise up and demand that the Constitution must be respected and followed. The most amazing part of it all is the fact that we had the Supreme Court that authorized the the suspension of allocation of funds to the government of Rivers State until elections into the local government councils are conducted, and that the budget is passed by the State House of Assembly. And soon after the government was suspended, a sole administrator appointed, the federal government authorized the release of those funds to the sole administrator to spend. So these are the infractions on the Constitution. But the only way that this can be reversed, the only way that this can be checkmated, is if the citizens rise up in one voice against this kind of illegality. Other than that, nothing can happen. And I can bet you, our politicians know very well that the citizens will not do anything when matters like this come up. And that's why they keep doing what they are doing. And it will continue until the people rise up in one voice to stand against this kind of illegality. Over.
Umaru. Ibrahim Umaru, please kindly unmute.
Hello, good evening. Good evening. Can you hear me, please?
Yes, sir.
Hello, can you hear me?
Who?
Can
Umaru.
hear you, Lati.
Okay, good. Thank you very much, the moderator and our presenter. Thank you very much, Levenus, for your wonderful presentation. This is massive, and only God that will bless you for replicating your knowledge to us as young Nigerians. My questions are like this. One is you talk about the supremacy of the Nigerian constitution towards all other constitutions in Nigeria. But a couple of times you see the public officials or the government officials are the first people to violate or disobey the Nigerian constitution and regarding their own constitution as supremacy. So my first question is, how can the ordinary Nigerians like us, the youths, can hold them accountable on that? Then secondly, about the constitutional amendment, like one of my brother that asked. In 2021, the Nigerian Constitution, 1999 Constitution, was opened, and we held a public hearing. Like I think I remember 4th April or something of that in Abuja, where I was able to be part of the people that will submit their own memorandums and observations, articles. So see how we, and as an associations, to see where it's supposed to be amended and where it's supposed to be. As a president of Arewa Youth Movement, I was able to be given opportunity to submit my memorandum. The funniest thing and the surprising thing, I can say, is the painful aspect of it is, when I submit my articles, I think in my memorandum number 8, where our association, and I present them that the 1999 Constitution should be amended in such a way that all the ex-governors, any other ex-governor should be banned from contesting any seats in the National Assembly, because they take it as a jungle where they will come and hide, and it's a place where that they have to raise motions to create acts, laws that the youth of Nigeria would benefit, but they use it and they take it as a hiding jungle for themselves. To the surprising matter, when they finish capturing all these things, when I'm submitting my memorandum, all the House, all the audience and the press were impressed of this article. But because there is ex-governors like Kasim Shettima, the current vice president now, there is Rochas Okorocha, there is many ex-governors, Al-Makura, other governor of Nazara, all these ex-governors, they were senators there, and is in front of them. When they return back to the National Assembly, that's motion, that's memorandum, article number 8 that I submitted is the first thing they start removing. And as me, as an individual and association and a youth activist, I don't have any room again for me to go back to the National Assembly and hold them accountable. Why did they remove it at that early stage? So now, how can you advise us and how are we going to go about that? Then lastly,
thank you very much. Yes.
Lastly, there is one House of Representative from in the 9th Assembly from I think Gombe, like Duku, or somebody Aisha Duku. She was able to raise an article or act of creating Electoral Offences Commission. So I was too able to be there, trying to see that the schedules, who is responsible, which of the agencies is responsible of punishing electoral offenses. I'm telling you, they created a cluster. They stand on it that they did not specify a specific agency like EFCC, ICPC, or any agency that will punish that electoral offenders. They just put it as a cluster, as even if you catch them accountable that they have committed electoral offenses, no any agency that is specified in the constitution or in that act that will punish them. So they will go for free. So how are we going to tackle all such things that if they are empowered, they will create a cluster that they will close all the gap, no way to catch them. And we as a youth advocate and youth activists, we're trying to see that Nigeria will be good for us. We don't have space. Thank you, sir.
Thank you very much, Umar. Very brilliant point you have made. And the only thing I'll add to you, don't give up. Don't give up. It was a good attempt to see you participated in the public hearing and made a very useful contribution by way of submitting memorandum for the aspect of the provisions of the Constitution that was to be amended. Yes, I actually agree with you. That was a big issue at the time. But you see, that is the conspiracy of the elite that we often talk about in Nigeria. So at the end of the public hearing, nobody monitors the legislature, and that's a big problem. But you see, all hope is not lost, and the only way to hold these people to account is through the constituents. Every senator came from a senatorial district. Recently, they were talking about recalling Senator Natasha just because she raised a fundamental issue, okay? But it failed because it was all part of a grand conspiracy. That's why it failed. But the Constitution made provision for recall of National Assembly members who, having been perceived by their constituents to not represent their interests, can actually be recalled. The provisions of the Constitution for the recall of National Assembly members is very clear and well circumscribed within the Constitution of the Federation. So that's one way to hold them to account. If they fail to do something, you can recall them. And you may not necessarily wait until their 4-year term is over, but you can recall them from the National Assembly, having failed to represent you or represent the interests of the people. So that's one way you can hold them. I agree with you that the National Assembly, particularly the Senate, is more or less like a retirement ground for former governors. In fact, it was very, very disgusting, just for lack of a better word to use, to hear the Senate president address Senator Seriake Dixon, who was a former governor of Bayelsa State, and who was trying to make the point that on the proclamation for the declaration of a state of emergency in Rivers State, there is need for the Senate to ensure that the constitutional provision is followed, which was basically to count the vote and not to proceed by voice vote. And I heard the Senate president say to him, I was a governor like you. So you can imagine it was more of personal ego. Okay. The personal ego came into play in and this, of course, could be the case with other senators who may not have been governors before. So you can imagine those who are governors may be threatening the others to say, I was a former governor, you are not, so I understand this whole process more than you. So this is the kind of thing you find in our kind of democracy, because you have, in the first place, people who shouldn't be in a particular office occupying those offices. And so you have all of this kind of shenanigans, happen. So I agree. The Senate or the National Assembly shouldn't be a retirement ground for former governors. Once you govern, you should go back to your private life, because some people have made government in Nigeria what do I call it? Their career in Nigeria. So you have people who have been in government from their youth to date. They are still in government. They are still there, and so on. There are people who have been in that assembly from 1999. Some of them were in the House of Rep. Some were even in House of Assembly, then they moved to House of Rep and then to Senate. Some were in House of Rep, they've been in House of Rep and then moved to the Senate, and they are still in the Senate till today. Some persons were born when these people were in office and they are still in office till today. So this is the kind of thing. It's not a birthright. But then, because our electoral system has not been strengthened to the point that it is self-accounting, and that is the reason why these people continue to perpetrate themselves in office. I'm sure you recall the case of even the Senate president who did not run for primaries, senatorial primaries, because he was a presidential aspirant and participated in the presidential primaries in the APC. So how did he eventually appear in the Senate and all? So there are still lots of issues. The issues around electoral offenses. Yes, I agree. And because we have not as citizens taken the steps to hold our senators or representatives in the National Assembly to account, that's why they keep doing the things they are doing. So when you send in a memoranda, for instance, or a private member raises a memo for the establishment of an independent electoral offenses tribunal, it dies a natural death, because they know that it will come back and haunt them because of the way they get into office. So at the end of the day, they will kill the process, or they will delay it, or just subject it to some what do you call it, legislative tapeism, and it dies there. So that's why some of these things don't come to the light. They don't come to the light. And even if it is passed, the president in office at the time, if it's not someone who is committed to constitutionalism, fairness and justice, it will not work. We again, this is why sometimes, a lot of people will say, oh, we wish it was Goodluck Jonathan, somebody who could willingly surrender because he saw that, okay, yes, he lost. But, not every sitting president will lose election and submit. No, it's not possible. There must be some manipulation to change the system, But that man saw that, yes, the tables are tilted, and he willingly offered to leave office. So perhaps if we had someone like that, coming as the president, we would have had a independent electoral practices tribunal established. He is the one that brought in the direct data capture machine to enhance our elections in Nigeria, And rather than make that system well strengthened to make it self-accounting, we have seen the kind of things we have seen today, and basically so that the ruling party continues to perpetuate itself in office. So I'll just pause there. Yes, there are challenges, but I must say that there are still approaches to ensure that we hold these people to account through the recall process. And that's something that we need to try out. If it works on one, I bet the others will sit up and they will begin to think with their head and not with their legs.
Thank you. Thank you so much. Thank you. Maxwell, thank kindly
All right.
unmute.
Yeah, thank you. Thank you, moderator. Thank you, sir, for the wonderful session. You've taken us through the historical development of constitution in our country. Why answering the other persons, you've been able to throw light. I was confused, but I still want to ask one question. Because when it comes to issues of constitution in Nigeria, an average Nigerian would always think that there are disparities embedded therein. They will tell you the constitution have been made for the political class, the rich people, and the rest. So you've thrown light on some of the things, but I want to know, what's the frequency of amendment? Like, how long does it take for a constitution to admit the gaps therein, and there is an amendment? I want to know. Thank you.
So the Constitution did not specify the frequency and regularity of its amendment and reviews. However, what defines whether a provision will be amended may be the contextual situation of the country at the time. Okay, the need. Is there a need for such an amendment? Are there peculiar circumstances that have arisen to warrant that? For instance, okay, let's take the Rivers case, debacle in as an example. Given what has happened in Rivers State, some persons may want to suggest that maybe that provision of the Constitution is not so clear. So let's make it even more explicit so that no president ever imposes a state of emergency and remove democratic institution. So let the provision be clear to say, in proclaiming a state of emergency, no democratic institution shall be suspended. So maybe if it's clearly spelled there, no president will ever do that. Goodluck Ebele Jonathan, when he was president, declared a state of emergency in the states of Borno, Yobe, and Adamawa. He never removed any democratic institution. What he did was to bring in military, imposed, curfew. So say, look, don't be caught in the crossfire. From so time to so time, be in your house so that the military can patrol the streets and be able to apprehend insurgents and terrorists who had invaded our land. But then the
Elisa, can you help check your mic? We are not hearing you. We're struggling to hear you.
Oh my God, I'm so sorry. I've been talking to myself all along. Can you hear me?
Yes, clearly.
Yes.
Okay. All right. So what I was saying, I didn't know I was just talking to myself. What I was saying is that the Constitution did not define the regularity for the amendment of the Constitution. However, there are certain factors that could warrant the amendment of the Constitution. For instance, there might be a need to amend the Constitution. There may be contextual situation that may have arisen to warrant the amendment of the Constitution. And I'm saying that if we take the case of Rivers State, if we take that case in point as an example, perhaps there may be a proposal or recommendation for that provision of the Constitution to be clearly spelled out, such that in declaring, for instance, in declaring a state of emergency, no democratic institution shall be suspended by the president. So if it is put there clearly, no president will ever attempt to do that. Okay, so that might be one ground. So based on need or based on contextual situation. Two, the context may also be that, look, we've had a lot of electoral fraud in this country. Going forward in 2027, we don't want to allow that to happen. So let us amend the Constitution to provide for the establishment of an electoral offenses tribunal, okay, that will look at both pre-election, pre-election, election, and post-election matters. So in setting up that, in putting that provision clearly in the Constitution or in the act establishing and in the Electoral Act, it becomes a matter of law that has to be set up. So this kind of context is what defines when a constitution can actually be amended or an extant act of the National Assembly can be amended. But in terms of defined regularity, it is not in the Constitution. But the need or context may be the reasons for the amendment. I hope that answers your question.
Thank you, sir. Can you permit us to take another question from somebody who already asked the question? Just the only person left.
Okay, let's do that and then can round up.
Okay.
Yeah, come on.
Yes, Mr. Timothy. Kindly unmute, please.
Okay. Are you with me, sir?
Yes.
Yeah, thank you so much, and apology for having to come back again. Yeah, I observe that since independence, it is the incoming government that promulgates the Constitution, and most especially the civilian government, and most time it is usually the National Assembly. But in the case of 1989 Constitution, as of the time the Constitution was enacted, it was still the military head of state that was in power. In fact, we didn't have a full National Assembly until 1993. So I wonder why that Constitution was labeled 1989, when as of the time it was enacted, it was not by a civilian government. And as of that time, the National Assembly has not been constituted. That is one. Number two is the fact that, considering the fact that we are using written and rigid constitution in Nigeria, and by the virtue of that, every other law apart from the Constitution must actually bow for the provision of the Constitution, since it is rigid and written. But in the case, and at the same time, we are practicing presidential system that actually allows for what we call judicial review, which gives the judiciary power to actually review the activities of the other organs of government and determine whether what they do is lawful or not. And now, when we look at the case of Natasha, I think a day before she was suspended, a court ruled that the Senate should be restrained from taking any action against her. But unfortunately, the following day, the Senate went ahead to suspend her, claiming that it is the Senate order. Now, my question is this: does that mean the Senate order is superior to the Constitution or the order of the court? Or what do you think actually happened there? Because I felt since the court has ruled and there has not been any other decision from the court, we expected that at least the Senate should actually hold on until any other directive from the court. But unfortunately now, we are now having a kind of clash between the court's order and the so-called Senate order. So what do you think happened there? Do you think the Senate did well by ignoring the order of the court? So that is my question, sir.
Okay, thank you. First, to address the issue of Nigeria's constitution. Nigeria's constitution, well, yes, it's written, but you said rigid. Is it rigid? I think it's a flexible constitution because the legislature can actually amend the constitution through the ordinary lawmaking process, which of course we had established earlier, which begins first with identifying the amendment to be made, and then a call for memoranda, and then public hearing, and then it goes to the state legislatures, and then it comes back again, and then it's finalized and passed. So those are the ordinary lawmaking process. For a rigid constitution, once the law is written, it is above any other law. So you don't even amend it. It stands where it is. So having said that, the point about military always being the one that gives us a constitution, very true. Very true, because the military rules by decree. First of all, when the military comes, it suspends the constitution by a decree. So what becomes the law by which the country is governed is military decrees. Therefore, by the time the military is transiting, it has to now bring forth, it has to bet a constitution. If it is going to hand over to a civilian administration, it has to midwife a constitution by which the civilian administration will be governed. So by a military decree, it establishes a committee or an assembly or conference to give the country a constitution. So that's how you came about the 1989 Constitutional Conference, and of course others that have taken place as well. So that's what happens. But in a civilian regime, what you do is the amendment, because you already have a constitution in place. What you do is amendment of the constitution, which is the reason why many pro-democracy activists have talked about a sovereign national conference, because when you talk about a sovereign national conference, you are not now amending the constitution. You are now going to tear down whatever constitution is in existence to organically evolve a completely new constitution. So it's either you do that by a sovereign national conference or by a national conference for constitutional development for that purpose. An example is the one that President Goodluck Ebele Jonathan did in 2014 when he established the National Constitutional Conference. And basically, it was an attempt to give Nigeria a constitution by way that follows an inclusive mechanism. But because you see how the people were selected that came to that conference. So that's basically the reason why you always have military midwifing a constitution, while a civilian regime administration basically does more of amendment because there is already a constitution in place. So those are the two different things. So in the military, there is no constitution. They rule by decree, so they have to midwife one. In a democracy, there is a constitution. So what is done is to amend based on context and based on need, which I've explained earlier. With the case of Senator Natasha, the Senate rules are not superior to the Constitution, which is the reason why the Constitution, in establishing its supremacy, clearly states any other law that is inconsistent with the provisions of the Constitution shall, to the extent of that inconsistency, be null and void. If you look at the recent altercation that took place between Dr. Mrs. Obieze at the National Assembly and the representative of Senator Natasha before the Senate committee, what the Senate committee was saying is they have to go on. Yeah. So before they could enter into any discussion, the chairman of the Senate's Ethics Committee had asked that they go on oath. And they said they can't go on oath because there are observations, that they have, and they need to make those observations very clear, put them on the table before they can do any other thing. That was where the disagreement, started. So, clearly, you cannot subject people who are not senators to the Senate rules, and which, of course, clearly, tells you much more than what you have seen, that there is no it is difficult to get justice in matters of that nature if you are going to be subjected to rules by which the Senate is governed, because the moment you subject yourself to those rules, they will, by those same rules, rule you out of anything that you're doing. That was the wisdom for why the Dr. Obi and the team refused to go under oath for the purpose of that hearing. And the case that many people are making is that the Senate rules are not superior to the Constitution, and which is the reason why there was recommendation for an independent panel of rather than the Senate sitting as a judge in its own case. Okay, because the election at the Senate president, and the Senate president is the one that set up the meeting, so be the one presiding over that matter. It should go to an independent body to conduct that investigation, where the Senate president and Senator Natasha hear petitions before that independent committee. So these are the issues surrounding the Natasha Atapa's case.
Yeah, thank you, sir.
Thank you so much. Thank you for an insightful session today, and would always appreciate your showing up intellectually, physically, and
Thank you. Thank you very much, Samsudin, and thanks to every one of you.
thank you, sir. In the absence of no further questions, can everybody please kindly unmute to say a big thank you to our facilitator for today. See you all tomorrow. Please kindly unmute.